same one, it's the same thing that all the employees.
Thank you, GrassRoots, and thank you to everybody that's joining us this evening. This is the Aspen City Council work session for July 11th, 2022. On our agenda this evening is the CIRSA elected officials liability training. Joining us this evening is Sam Light, General Counsel for the Colorado Intergovernmental Risk Sharing Agency, CIRSA. Want to welcome you. Thank you very much. Sarah, would you like to introduce any more than that?
Just briefly, I'd like to say it's been a pleasure getting to know Sam a lot more. It's been about a year since I joined the board of CIRSA, and I have really counted on him a lot more, and his wisdom and him pointing me where, not necessarily on legal items, but where other jurisdictions are experiencing similar things as we sort of hunt and peck and see how other communities handle issues. So Sam is much more than legal counsel in what he's offering to the CIRSA membership. And I hope you enjoy this evening, and we'll be taking notes for things to follow up on for you as well tonight. Thank you.
Great. Cool.
Thank you. Thank you, Mayor. Thank you, Council. Thank you, Sarah and staff, for having me up today. It's great to come up and visit with you all for some training this afternoon. So as was mentioned, my name's Sam Light, and I'm General Counsel for CIRSA. CIRSA stands for the Colorado Intergovernmental Risk Sharing Agency. That's a mouthful, so we just call it CIRSA. First thing I want to say is thank you for your partnership in CIRSA. A bit of a historical fact here, the city of Aspen was one of the original members of CIRSA in the property and liability program. You joined our pool in 1982, our first year of operation. So thank you very much for your enduring support and participation in CIRSA. We very much appreciate our partnership with you. Just a little bit more background about CIRSA, just to give you a sense of our size right now. We've got 283 members. That's about 279 in our property and casualty program, and then about 140 in our workers' compensation program. As you probably know, CIRSA is not a commercial insurance carrier. We're what's called a public entity self-insurance pool, formed under Colorado law. Our only members, our only book of business, is Colorado cities and towns and affiliated entities. Affiliated entities being things like urban renewal authorities or housing authorities, like your housing authority is a member as well. So we appreciate our longstanding partnership with you. We're controlled by Colorado cities and towns and who pay our contributions, and we provide workers' comp, property casualty, and property coverages. As Sarah mentioned, our directors, our leadership is made up of representatives from Colorado cities and towns. We're very honored to have Sarah on our board of directors at CIRSA. So this evening's presentation, I'm going to share my screen in just a minute here if I can get this going. And we're going to, there we go. Your staff helped me set this up. There we go. Let's see. All right. I'm going to do an elected officials training. I know that at least one of you has seen a somewhat current version of this because I met with the Housing Authority, I think it was last year. But this is a little bit refreshed and updated for elected officials. As I understand it, most of you have been on council for a while, is that right?
At least a year.
At least a year or so? Okay, and then we have some
Is that an anniversary?
some folks with long-standing tenures in public service as well. Well, I hope whether you're brand new, fairly new, or have got a number of years in public office, that the suggestions that I make today are helpful to you. I want to make the training as helpful as I can, so feel free to ask questions as we go through the materials, whether you're brand new or been around a while. I hope the suggestions are helpful to you in kind of refreshing commitments to certain risk management principles around being in public office. Just a couple other housekeeping things. I put a couple of handouts at your places that I'll touch on as we go through the materials. And then some of you may have seen this or have a copy already, but I put at your places CIRSA's Ethics, Liability, and Best Practices Handbook for Elected Officials, which we originally published in 2015 and republished in 2019. And it talks about risk issues from an elected official's perspective. We hope it's helpful to you in just kind of highlighting some of the things at a leadership level that you should have on your radar in terms of helping the organization effectively manage risk. This evening, I'm going to touch on the role of public official. We'll talk a little bit about transparency rules, organizational structure, and how that influences liability. I'll touch a little bit on due process, you know, that quasi-judicial process, when you make decisions affecting people's property rights. That could be a couple hours in and of itself, but I just want to touch on a couple points there. We're always happy to do additional quasi-judicial training if you like, but I do want to put a couple of things on your radar to kind of refresh our commitment to some of the due process, what I call due process rules of engagement that govern how you make those decisions. And we'll talk a little bit about ethics. I have a couple of standard disclaimers that I need to make for all my trainings. Though I am an attorney, this is not an attorney-client communication. It's a training resource only. But as I said, feel free to ask me any questions that you have. But I've developed over the years in doing these trainings a pretty good radar for what I call a live one. You know, sometimes the question will be, Sam, I've got a question. What if another member of the town board does this? And everyone's eyes widen and the hair stands up. Oh, this is going to be an exciting discussion. My radar is going off telling me that that might be the live burning question of the day. So for that, you're going to want, if you need legal advice, you're going to want to get that from Jim and his team. Same thing with administrative matters. If my radar is going off and says, well, that sounds like a Sarah question, then I may give you a couple of thoughts from CIRSA's risk management perspective, but you'll want to rely on your attorney and staff for live burning issues of the day, okay? I've organized my presentation around essentially what I call suggestions for success in public office, and they kind of revolve around refreshing our commitment to some principles that are, you know, sort of half risk management, well, maybe a third risk management, a third legal principles, and a third kind of good civics. And I think if those things come together, it helps you manage risk quite well. My first suggestion is commit yourself to the role of public official. That sounds pretty obvious, right? But whether you're fairly new or been around a long time, I think it's always important to remember and, you know, refresh our understanding that when we became an elected official, right, our role and relationship to the community changed dramatically. You're no longer just a citizen, Aspen, right? You're now a government official, and that's a 24/7 job, despite what some folks may say, right? Not saying don't have a personal life, please do, right? And please enjoy that. But the way it translates to risk, I think, is in the eyes of your constituents, right? In the eyes of the citizens of Aspen, when they're interacting with you, particularly on matters of city business, but not exclusively, but they will always, right, perceive you to be talking as a representative of the council and of the city, right, and of this organization. That's even true. You could tell them over and over again, this is only my personal opinion. This is only my personal, and what are they filtering? City council member, city council member, city council member, right? And as they should, our words, our deeds, right, our conduct has meaning, has impact, leaves an impression. If someone thinks it wasn't what they expected, for them it may leave a residue. And in difficult situations, it can create potential risk, including risk of claims. So I think it's important to kind of keep that in the background in all your interactions with folks in the community. Recognize also you're no longer an outsider to local government. You're now the ultimate insiders, right? And it translates to risk this way. Once you're on the inside, the rules stick to us, right? In the citizen or activist world, there are folks that are avowedly certain that they're more effective from the outside, right? But they have the luxury of staying on the outside and doing things that you don't have the luxury necessarily of doing, given the rules that apply to the way public entities and local governments have to operate. And now that you're part of the ultimate insiders, the city's ways of doing business, the city's ordinances, rules, the council's code of conduct, all of those things guide the way that we have to do our business, and they stick to us as council members. So keep that in mind. You no longer have the luxury, right, to say, well, that rule that I wasn't in favor of or didn't like, maybe even didn't like when I was seeking office, well, now that we're on the inside, if it applies to council, it applies to each of us individually. And yes, it may be true that if I get a majority of council members to come along, we can change that rule or that way of doing business. But for the rules that are in place and that guide our decision-making, we're bound to follow them. Recognize also that council, of course, is at the top of that leadership pyramid, at that governance level. And maybe when you sought office, maybe you were interested in a single issue in particular. I don't know, maybe it was STRs. That's not a big issue around the mountain communities. No. What? Sam's talking risk, STR.
Better than timing.
But whatever the issue was, right? Usually, from that outsider perspective, seeking office, we have a handful of issues or a couple of issues that we're very passionate about, or maybe we were a critic or a proponent of something that the city was doing. But now that you're on the inside, the lens is broader than that. And with elective office comes the role of being a representative of the organization, a fiduciary of the corporation, right? The city's a corporation, and an ambassador of the organization at all times. So I think it's good to keep that broader perspective in mind, even if, some of the issues are coming from you as a council member, maybe they're not the ones that you're that passionate about. It's an interesting job because there's such a wide variety of things that you do. You have to deal with utilities, land use, budget, an infinite variety of things, and some of them you may say, I'm not really particularly interested in the audit report or whatever it may be. But I think with the role goes the commitment to being a great ambassador, a great representative on behalf of all issues that come in front of council. And I think committing to that will be a good hallmark of your tenure if that's what you decide to do. All of those things I think suggest to you that in the eyes of your community, right, remember that you're always a public official. Recognize that whatever your role was before you sought office, now you are a legal fiduciary of the obligation of the organization. That means sort of the overarching responsibility includes the protection of the city's interest and assets at that high level. I think staying at that high level, kind of one of the guiding principles for decision making is what's the right thing to do for the city as a city. And hopefully, that'll stand the test of time. It's probably true that a succeeding council may come in and revisit some decisions you've made, or you may be doing the same with some policies that were in place. But I think looking in terms of that, what's the best thing to do for the city as a city will serve you well. I know it's not easy. Sometimes, hopefully not all the time, but sometimes it's tough. You're going to have this your meeting chambers, the room will be full. People will be standing up during public comment with a wide variety of opinions on what you ought to do. First person during public comment will stand up, council, do this. The next person stands up and says, do exactly the opposite. And passions are high, emotions are running high, and that's, again, that situation where you're thinking to yourself, that's right. This is not a job where I'm going to make 100% of the people happy 100% of the time, right? But one of your prerogatives in that kind of situation that I'd suggest to you to help you do your jobs effectively and help you manage potential risk in those difficult situations is you always have the prerogative as the elected leadership to say to yourselves, do we need more time or more information, all right? Take the time that you need and get the information that you need as council members, right, in service of that broad principle, making the best decision for the city as a whole, right? Sometimes that can be frustrating to citizens. Maybe they'll stand up and they want you to make a decision tonight, but if you council members, say staff has hit on some new points here, or public comments raise some new points, we need to think about those a little more. Maybe we need to let this coalesce or gel. I think it's your prerogative to take that time and set aside more time if you need to deliberate with each other, but all in service of that guiding principle, what's the best thing to do for the city as a city. The new folks all took an oath of office, right? We get that done?
Old folks, too.
And the old folks, we just had an election, so we had some folks, some incumbents reelected. I swear to uphold the Constitution, the laws and the charter, right, laws of the state of Colorado, charter and ordinances of the city. Phew, we got that done, because you got to do that in like 10 days after the election or something like that.
About 30, but yeah.
Whatever, right, after you get that certificate. So again, may not be on the forefront of your mind, but I think it's important to check in on some things that are embedded in the oath of office, because there are certain commitments there that have meaning for you ethically, legally, morally, right? I think the oath includes a commitment to respect your role and responsibility in the organization. We'll talk about how everyone in the organization has a job description and how that translates to risk. You made a commitment to lawful conduct, swear to uphold the ordinances and charter of the city, right? That includes following the city's rules and procedures and making decisions, applying the city's criteria, even if sometimes they weren't exactly just the way we wanted them to be. But that's okay. You can work on that later as a legislative matter, right? You all, of course, became subject to the city's code of conduct that governs ethical standards for you all. We'll talk a little bit about that. And then maybe my last bullet here doesn't seem to flow as neatly from the oath of office, but it's probably a commitment that's embedded in the oath, right? When we were elected, we became, what, one contributing voice, but to a single body. And that body speaks with one voice, the voice of council, right? Sometimes that's pretty easily expressed. It's a 5-0 vote, or a head nod, or Sarah asked a question, it's a universal thumbs up. That's comforting, right? But sometimes it's going to be harder than that. But whatever it may be, whether it's a 3-2 vote or a 5-0 vote, I think embedded in the oath is a commitment to respecting at the dais each other's differing approaches to discussions and deliberations, appreciating each other's differing philosophies, right, and perspectives on issues, all in terms of working towards that single voice of the council. And even when it's a 3-2 vote, recognizing that, if I was on the short side of that vote, well, sometimes I win some, sometimes I lose some, but we're all working towards that one voice of the council. One of the job descriptions of the elected and appointed leadership in particular, but everyone within local government, because we're so front and center and transparent and available to our citizens, is to provide good governance, right? That's really the new folks. Who likes process? Do you like process?
Word.
You got to like process, because that's one of the products of local government, irrespective of outcome. Process in and of itself is a product we deliver. We provide a forum and a location for citizens to come in front of its elected leaders, right, and talk about the needs and wants of the community, and then you all get to decide how can we put governmental resources on those needs and wants. That could take a long time. Sometimes we get a bad rap in local government, right? It takes forever, takes a long time, but be a champion of the process, irrespective of the outcome, and commit yourself to providing good governance. I think at the end of the day, in terms of risk management, part of this is just committing to a few core civics principles, and I've listed those on the left-hand side of the slide, and I think if we recommit ourselves to the civics principles, that by and large, the corresponding legal issues will take care of themselves, like commit yourself to openness and transparency, and we'll have few, if any, disputes, claims, litigation over compliance with the open meetings law, open records laws. In the service of transparency, particularly for the new folks, just one example of that, being in public service is a lot different than private service in terms of like the way we use email, right? Do we all recognize that the emails that we send and receive wearing our hat as a city council member, right? That by and large, those are public records, open for public inspection. That even if only one member intended only one other member to be recipient of that email, if that request is made to the clerk's office for emails that relate to performance of your public duties or involve public funds, then by and large, those emails are a public record. There are certain exceptions that your attorneys will advise on and that your clerks are well versed in, where certain records are not subject to disclosure, but the presumptive rule under the transparency laws of Colorado is that the correspondence of elected officials is a public record. Did you have a question?
Yeah, I don't know what certiorari claims are.
So let's jump down there. I'll take them in that order. Commit yourself to predictability and even-handedness, and you'll have few, if any, claims where someone says, well, you violated my equal protection rights. The certiorari claim is this. Let me give you an example. You got a lot of, I hope it wasn't the first thing you got from the clerk, but you got a lot of ordinances. You got this big book. Maybe they don't publish the books anymore. Maybe it's all online. So you got right? You got ordinances, resolutions, all these standards that apply and that create a box within which decisions have to be made, particularly on quasi-judicial matters. If you're approving or denying a development plan, there are standards that are in place. And while those are in place, we need to commit ourselves to apply them in a predictable and even-handed manner, right? you don't want to be in a situation where, let's say one applicant comes in for, do you have special use permits? Council decides those? Someone comes in for a special use permit, they say, yep, easy peasy, the rules were clear, I understood the application requirements, I went in front of the Planning Commission and Council, it was a good hearing, understood what was expected of me, the criteria were straightforward, got my approval, no problem. But then someone in the same position, their view of it is, well, that's odd. I feel like there were some new application requirements put on me that I didn't think were part of the requirements. There were some strange things going on in the hearing, but most concerningly, the night that my special use application was up, that was the night that the Planning Commission, for the very first time, took a novel and unprecedented interpretation of their rules in terms of turning me down, right? That's the risk there of, not applying your rules in a predictable fashion. At the end of the day, if there was no support, legal support for that novel and unprecedented interpretation, that's when you're going to face a certiorari claim potentially. Certiorari claim is a Colorado state law claim that's basically saying the decision that was made by the quasi-judicial decision makers is arbitrary or capricious, was not supported by their own rules, okay? So the equal protection one is obviously if they try to set up that situation.
We tend to refer to those as Rule 106 claims and that kind of
Administrative
context.
procedures.
Yeah.
Yeah, it's under 106A4 is this, in general, very general. It's not where all the action is, but in general, if an applicant wants to challenge a quasi-judicial decision in state court, their main remedy, if not their exclusive remedy, is to challenge it under 106A4. They got to bring that action within 28 days, and they're saying the decision was arbitrary or capricious. The reason I say it's not where all the action is, if they believe or have an attorney who believes that maybe there's an equal protection violation in there or a due process violation in there, right, then they'll couple their state law claim with a federal claim, something like that, okay? Commit yourself to fundamental fairness, right, and you'll have few, if any, due process claims. That most often comes up in quasi-judicial proceedings, but from where you sit, your staff is taking care of the lion's share of the work to get your hearing queued up, right? But if something comes up during the hearing, you'll want to exercise your prerogative and your responsibility to make sure you slow it down and ask staff, are we okay from a procedural standpoint? Maybe it's as odd or simplistic as someone stands up during public comment and they say, I didn't get notice of this hearing, I object. I always thought that was a little odd because they're there telling you they didn't get notice. So it's usually not that easy a situation, right? But maybe something else. They claim that notice was defective or that some documents aren't being handled properly or there's something else going on with the procedures. From where you sit, you always just want to slow it down and ask the clerk or the staff or the attorney or the whoever's supporting that hearing, are we okay? Is notice proper? Have we got any issues that require us to slow things down or do something different to protect ourselves from that procedural due process risk? Okay, and sometimes, very infrequent, but once in a while, there may be some problem that came up that counsels towards a need to continue a hearing. And if that happens, that's okay. It's better to give the process that's due, right, than run the risk of not having given the process and having someone later in a claim situation prevail on that claim. So,
Yeah. Let me ask a question, just kind of coming back to the Satori claims issue.
yeah.
And perhaps you're going to cover it later in your presentation, so we don't really need to go into it in depth, but isn't a big part of this having appropriately created the record?
Yes.
Because once someone is going to make those sort of claims, you can't go back and correct the record. It's the record from that meeting, and that people have put on the record the reasons why they're voting for or why they're voting against, or what criteria it did or didn't match, what the findings were in the decision.
Right.
And that's your real protection in those sort of cases, that you've created an accurate record.
Yeah, for the certiorari claims, and I'll look to Jim if he wants to add comments when I'm done, but the quasi-judicial hearing that you hold, that's where we're making that one and only record that will be reviewed by a court if you're challenged in court. So that's why we'll touch on later during deliberations matter.
Okay?
By the same token, when you're doing deliberations, there are no silly questions, right? And take the time that you need to interact with each other about why do you feel this way and what are your thoughts on this criteria, that criteria. So we'll talk more about it in the later part of the discussion.
Thank you.
Yep.
Sam, I got a question for you. Do you run into members of municipal councils often that don't believe in any of this? So, and right now you have five people up here that are committed to serving their community and do it through the process that is available to us.
Yeah.
That's why we run for office and why we serve. But I know other communities that have people that are really against process, that are really not welcoming of being an insider and are used to being an outsider and that kind of thing. Do you run into many people that are that challenge these fundamentals much, or
Not too much.
okay?
Not too much. You know, and I'll be frank with you, sometimes they identify and then the problem comes up later, and then there's more appreciation of the risks that come up with that, right? But the other thing in the training from this perspective, I always say it's a dangerous way to look at your risk is what's the, if you're defining risk in terms of what's the potential consequence, I think that's an incorrect way of looking at it in terms of responsibilities as a public official, right? I think we always have, as a starting point, a good faith obligation to discharge our service in accordance with the rules that apply to us, right? So I'll bump across once in a while, right? Someone will say, well, what's the risk if I do this? And how, you know, nobody's going to sue us over that. I'll say, well, the risk is faith and trust in government, right? And as we'll talk about more in transparency, all eyes are on us now more than ever. And things that we think, you know, once in a while someone has that idea, well, no one's going to challenge it. Things crop up. And more is known about how we do business than we think sometimes. So once in a while, I'll bump across an official who looks at it that way and says, what's the risk? I say, well, there could be, apart from legal risk, there could be above my pay grade, political risk, faith and transparency risk, erosion of public trust. We have some members who have longstanding disputes with citizens that don't end up in litigation, but become intractable problems where they're always getting pushback. And you know, maybe no one's crossed that line and filed a suit against them, but they're always pushing back and saying, well, you're not doing this the right way. So I think conservatively, you know, we have good faith obligation to follow the rules that apply to us. So we ought to follow them and not embrace that attitude of what's the risk of getting caught.
Yeah, I was going to say, similar to your question, but I guess the biggest thing I've really run into is not people not wanting to follow the rules or the laws, but perhaps chafing under the idea that we're one voice, or any council is one voice, and that, does that mean I can't really object, or I can't really speak to why I objected? And so I think the one voice is where I've known, whether it was a Terry Paulson or whether it's a Jack Hatfield or different boards who, you know, just wanted to maintain integrity by being a little apart rather than feeling like they were becoming part of a mind meld and had to compromise all the time and never really spoke their truth.
Yeah. Yeah. With a multi-member governing body, though, if everyone had was of the same mind all the time, then we're losing the diversity of input.
Yeah.
Right. And you have to, I've got a couple of comments later on, but I'll touch on them now. The idea of being aware of those dynamics, right? And if people, are we always in a safe space where people can express whatever opinion they have and feel like their opinion's heard and valued irrespective of the outcome? And I think particularly in this day and age, there's so much pressure on all of you from individual constituencies, right? And we each have our own constituencies and groups of citizens that we check in with. And there's a lot of pressure to deliver or be accountable to them that I think some of the dynamic I see, and probably that's the single most overture that I get for people when I get ready for the trainings, is how do we make sure we're coming together? Because we all feel like there's so much pressure on us individually to do things, accomplish things as elected officials. How do we pull that together as the 5 or the 7 to get things done? All right? So.
Thank you.
The last one, commit yourself to mutuality of respect. It may not sound like a predictor of risk, but I really think it is, right? Commit yourself to mutual respect with each other, the citizens that come in front of you, with the staff that you deal with. Because like I said, it's not going to be easy all the time, right? And there'll be some decisions where people are going to go home angry. They may even say to themselves, well, you know, if they say to themselves this, you're going to be all right. If they go home and say, well, I'll never agree with what council decided, but you know what? I get it now. They had a tough job. They had to take all those differing opinions, distill that down into one decision that was in the best interest of this city and this community. And you know what? I'll never agree with what they decided, but I feel like I was heard. I feel like it was a good process, and I feel like I was respected. You know, your faith and trust in the council as an institution is going to go way up, and your risk profile is going to go way down. The opposite can also be true. Someone could go home from that, and if their view of it, if their vibe is, you know, I feel like that decision was already made before I got there. I feel like it was a wonky hearing. I feel like they didn't listen to me, right? I'm so mad. I'm never going to agree with what they decided, and worse yet, I feel like I wasn't respected. Those are the people that sometimes then get so mad about it. They say, I'm so mad, I'm going to go see if there's a way to legally challenge that decision. So I think that would intersects with risk, and how that commitment is pretty important. Yeah. All right, let's pivot just a little bit and talk about organizational structure and liability. As I mentioned earlier, we talk about the concept of how everyone within the organization has a job description or a particular role or a particular lane, and kind of staying in one's lane is important to risk management. For the newer folks, I hope it wasn't your first question to Jim, but it's, you know, can I get sued in this job? Sure you can, right? But I'm going to stay at a 40,000-foot level and just start by saying you've got some protections. And we want to have good protections, and we have strong protections in Colorado because we want to encourage public service. My gosh, and if the risks were infinite and right on your doorstep every day, who'd want the job, right? But here's a quick overview of the primary protection you have. So in Colorado, and what I'm talking about here is, can someone sue you and hold you individually liable for something that you do as a council member, okay? So in Colorado, we have a statute called the Colorado Governmental Immunity Act, and it basically says that the city, and by extension the city's insurer, CIRSA, will defend you and pay judgments entered against you for acts or omissions as a council member. Good news. There's a catch. So long as, this is what the statute says, so long as you're acting within the scope of your employment and not acting in a willful and wanton manner. Two odd phrases there. Scope of employment may sound odd to an elected official because you're not a full-time employee like Sarah or other individuals in the city. But the takeaway for you just at this summary level is scope of employment is simply the phrase that's used in the statute, and it simply means everyone must know, stay within, respect their authority within the organization, right? Real simple examples, and you can extrapolate these from these what you like, but you know, different parts of the organization have been allocated either by your charter or by statute or by ordinance, different powers and responsibilities. So simple example, whose job duty, right? Whose authority, job duty is it within the organization to issue tickets in the municipal court?
The municipal judge.
The police, right? So whose job isn't it? The rest of us, right? Everybody else. You probably have a business licensing program, right? And so whose responsibility is it, whose job duty is it to make that initial decision of whether or not to approve or deny a business license? Is that
Finance.
Clerk's office?
Yeah, it's the finance.
finance director?
Finance director.
Whose job isn't it?
Ours.
Everybody else, right? Yeah, and it runs the other direction too, right? Whose job duty is it to decide whether this organization takes on debt?
And the voters.
Yeah, and the voters, and no one else, right? So that runs all directions within the organization. And it's simply recognizing that those allocations of responsibility are there to serve and protect you. They do have a claim risk. It doesn't crop up all that often, but sometimes we'll have claims where someone denied that business license. They'll file a claim, and we'll have our defense attorneys talk to them, and they get the complaint. The complaint says the defendant is the city of Aspen, or it's the, did you say finance director?
Yeah.
Finance director in their official capacity. That sounds right to me, right? They're either suing the organization or the the individual who made the decision in their official capacity. But sometimes they'll add other names to the complaint. They'll add some elected or appointed official or somebody else. And what are you doing? They're not a proper defendant. They didn't make the decision. And the claimant attorney will say something like, well, I get all that. I've read your org chart and I've read your ordinances and I know who's responsible for making the decision, but that's not my allegation. My allegation is that there were elected or appointed officials lurking behind the scenes directing that administrative officer deny that license or do something untoward. And so you could see it's right, bad conduct that we spot and we're going to avoid, but you can see the risk. It doesn't happen all that much. More day-to-day, it's recognizing and respecting that the allocations that the voters made in your charter or that you have made in your ordinances are there to serve and protect the organization and you as a council, right? If everyone's staying within their lane, then when I get that kind of suit over at CIRSA, it's easy to tell the plaintiff's attorney, hey, that attempt to name the elected or appointed officials individually, you've got no factual basis for that. Our org chart applies. There's no evidence otherwise. You need to dismiss them from the suit. And they get the picture pretty quickly when we tell them, if you don't do that, we'll file a motion to dismiss, right? And if we prevail, we'll get our attorney's fees, maybe less chance of getting them now, given some new legislation, but we'll argue for our attorney's fees, okay? So that's what's going on with that. The other interesting phrase is willful and wanton. And that's simply defined, it's essentially this. Willful and wanton conduct is conduct that's intentionally undertaken, designed to injure someone's protected legal rights, and taken with reckless disregard for what their rights are. I got a simpler way of describing it. I just call it bad stuff. And we know what it is. We're going to stay far away from it, and we'll be just fine. And it really is bad stuff, right? We don't get those kind of claims very often. But just to give you a sense of the most likely scenario where we get that type of claim against an elected or appointed official, is it's usually this. It's usually an assertion that an individual elected or appointed official acting individually, right, and misperceiving that they had some governmental authority that they actually didn't have, right, throwing on that cloak of governmental authority and doing bad things to someone for the wrong reason. That's the risk, okay? And that sounds like bad stuff. Sure is. And we're going to stay far away from it. It ties into your insurance coverage as well, because all public officials' liability coverage includes exclusions, which are intuitive, right? That we know that public officials' liability coverage is there to cover us for risks and claims when we're acting in our capacity as an elected official. So obviously there's exclusions for things like civil liability that flows from criminal conduct or willful and wanton conduct or malicious acts. Yes?
Yeah, I was just going to say, I remember way back in the day when Colorado Municipal League would do training videos about this area, and the one that really stuck with me was you are most likely to be sued by interfering in personnel matters, and that you can clearly tell your manager, I'm disappointed with the output from this department. But if you say, Joe Blow's got to go, you've just really crossed over between talking about the expectations for that given department and let the manager sort it out to something that's just not in your lane, and that's one of the only areas where you could be sued personally.
Yeah. Yeah, you've got this wonderful system, right, where you have the council manager form of government where in personnel matters, something comes up, Sarah and her team have it, right? In fact, your charter got a provision that I'll touch on in a second about that, right? But the way it protects you is then you're insulated from all that employment liability risk. And that's a great place to be, right? Something comes, and I'll give you an example about that in just a second because I've got a slide on that issue. Yes, sir.
Could you give us an example of willful and wanton offense?
Sure. Maybe it's an elected or appointed official not thinking clearly and conscripting somebody from the building department to, hey, make sure that person gets a red tag, and actually it turns out they're a business competitor, right? And misusing my authority to order that person be red tagged. That sounds pretty bad. Yeah. Or when everyone else in the room clearly knows that you have a conflict of interest, you're saying, come what may, I'm going to proceed anyway, and I'm going to do something against this applicant or this competitor when I clearly, undoubtedly have a conflict of interest and should have recused myself, that could be a potential risk. Yeah, that one is a little less likely to translate into a claim for civil liability, but it could at least
It's a bad look.
show itself as a breach of ethics. Yeah.
Yeah.
It seems to me that we inherit lawsuits. I think the first email I got on city council was naming me and the rest of the council individually for an action that, in first day on the job, I'm named on a lawsuit for something that happened with the previous council.
Yeah.
Happened to me in the county as well with the Grace Church, $10 million personally, and the judge refused to let it go in terms of personal decisions.
Wow.
I know.
But that felt good.
Yeah, that's
That kind of sets you up.
What's the salary?
yeah, that drives home the point. You're the insider, right? You get elected, you get your certificate, you take your oath, and then later that night on the agenda, you got an executive session about litigation, right? Or something.
Yeah.
Welcome to the club, that kind of thing. Yep. Any other questions about that? Just a couple of tips. Not all of these translate directly into significant third-party civil liability risk for willful and wanton or scope, but here's just a couple of tips to stay in a safe zone on this stuff, right? Respect the delegations of power and authority, right? Not only recognize, well, what's my authority as a council member, but knowing what parts of the power within the organization have been given to the manager, right, or the chief of police or a department head, right, helps everyone fire on all cylinders, efficient use of resources, and helps serve the organization well, right? In a single sentence, really the job description of the council is at that hierarchy of the job duties in terms of, as I said earlier, helping define needs and wants, dealing with governance issues at the high level, right? You're the part of the organization with the longest time horizon. You're thinking long-term planning, where do you want the city to be in 1 year, 5 year, 3 years, annual budget, master planning, long-term utilities planning. Once in a while, well, maybe more than once in a while, setting policy by ordinance, right? That doesn't apply to anyone in particular, but setting policy for the long term, maybe something like a SDR policy, something like that, right? That's that broader role, and then by your charter and your ordinances, administrative functions, day-to-day operations, executive functions are assigned to your manager and other staff, right, or to your attorney and judge. Recognize also that councils act as a group. In fact, we'll talk about in a minute how action requires that it be done in an open public meeting, but yours is a group role, and there is safety in numbers, right? I think it's hard, not always, but it's harder, right, to bring that individual liability claim against the single, you can hear it now, right, plaintiff attorney saying, well, I disagree with the decision council made last night, but I'm going to sue you and just you for that. You go, wait a second, I'm just one of 5 legislators who made that decision. So there's safety in that. There's also additional privileges which are beyond the scope of this, but when you're together in this room acting as a group, there are certain privileges that attach, quasi-judicial immunity, legislative immunity, mental process privilege applies to legislative activities, those kinds of things, okay? I think all of that probably reaches back to an earlier slide in terms of managing this part of the risk profile in terms of thinking of we as a council. It can be kind of a warning sign if the attitude is you do what you want as council, I'm going to do this, right? And particularly if it involves the rights of a third party, that's a warning sign, right? You have to slow down and say, do I really have authority to do that? And if the answer is no, we have to respect, no, that's not my role within the organization. This other warning sign may not translate directly to civil liability risk, but I think it's an important point. Mayor, do you have, during meetings, like an opportunity for each council member to make comments, council reports, something open?
Many.
But like near the end of the meeting, there's a chance for maybe for final council reports or something, and each of you gives a report on.
We're not muzzled.
Not muzzled, all right.
Yeah.
So the mayor calls for council reports and you say, Mayor and council, I've got something to report. Since our last meeting, I did this. If everyone else's reaction is, you did what? Right? That may not be a third-party liability risk, but it's a wise council that identifies that is as a potential issue for the council as an institution. Right? As a council, have we talked about and identified our norms, our expectations for how we conduct ourselves on behalf of the organization and on behalf of the institution of council in between meetings, so we don't have that surprise, right? I mention it because I don't want it to devolve into a liability risk. And additionally, I want the person who says, I did this, to feel like they're protected, but I think you only get there if the expectations are clear. Like if you all ask the mayor, why don't you go talk to the county? He comes back and says, you know, at the next meeting, oh, I talked to the county and I said this. And you said what? Right? So it's a kind of that squishy part of the job, but if we're asking individuals to do things individually on behalf of the council in between, have to make sure expectations are clear and understood so that the person is supported. Or conversely, the tougher decision is, or discussion may be, well, someone volunteers to do something. We say, no, I want to be a part of that. Or I think we should all be a part of that. Do we have enough fortitude to say to each other, no, let's not. Let's commit as individuals not to individually chase that issue ourselves, that's for us as a whole. And those are things that I think wise councils find time to chat about and see where those shake out, however it shakes out for you. Okay? Keep talking about the voice of council, but I think that role discipline concept does require some individual commitments that speak towards supporting the council as an institution, that speak to supporting the voice of council. Sometimes, you know, on a personal level, it requires us to set aside a personal interest or agenda item, even if it's our most passionate issue, right? Maybe you've got a legislative priority, you'd like to see an ordinance on this. But if 2 more council members won't come along, then I think part of the job, right, is of course that personal interest has to be set aside or temporarily put on the shelf in service of the work plan of the council as identified by the council. This next bullet, what do you think about this dynamic? You don't have too many of these, but it's okay if you do. You have some 3-2 votes, and you're on the 2 side of that. Is it okay to tell a constituent, hey, I didn't vote for that one? Sure. Who am I to CIRSA guy to gainsay that you can, you tell you, yeah, I didn't vote for that one. But does the message sound different if it's, I didn't vote for that one, but I'll tell you, it was a vigorous debate. And I fought like heck for my view, but ultimately council decided by a 3-2 vote that they would go a different direction. But you know what? I respect the council's decision. Does that lead to a stronger institution of council? It might. I think we always have the right to tell our constituents, hey, there's not one that I voted for, but I think in service of the institution itself, right? You want to do personal things that help make it the council a stronger institution when you're here and after you're gone. So there's a corresponding risk to individual behaviors, and that's sometimes you deal with citizens, constituents, probably talk to them every day almost, if not more frequently than that, right? Once in a while, you're going to have that discussion where you're getting the sense that they're reading a lot into what you're saying, right? Well, remember, if it's a council matter, you want to be protective of council as an institution and the city's process, or if it's an administrative matter, same kind of thing. But, somebody comes up to you and goes, yeah, can I talk to you about, I got this little building permit issue going on. And you're thinking to yourself, they're going to run with this, whatever I tell them, all right? You want to, no, that's not for me as a council member. Get in touch with our manager or our building director, and they'll get you to the right place. Or maybe it is something that's in your wheelhouse. Maybe it's a legislative matter. Hey, council member, here's why I think you ought to vote on this ordinance, right? And they're very strident in that, and they think you're going to deliver for them individually. Right? Remember that organizational principle of telling, hey, I'm just one of the council members. And I think that strengthens you as a council, because I know there's so many pressures on you individually to deliver for constituents, even on legislative matters, that good to remind them, hey, here's our process. It goes in front of council. I appreciate your individual viewpoints, but council ultimately will decide. I think that serves you well. Okay? All right, let's talk a little bit more about personnel. So, adherence to that organizational structure is particularly important in personnel matters. But, except for your few direct reports, elected and appointed officials are not employee supervisors, right? Your direct reports are the manager, the attorney,
That's it.
the judge, and that's it. What a wonderful place to be. Because whenever any employment issue comes up, you can turn to your point of accountability and say, Sarah, I heard this, and she's going to say, I got it. I got it. Sometimes it's got a little more hair and warts on it. Maybe you hear about it more than once, right? That you're still going to touch base with your manager who's going to take care of that issue. On the risk side of it, there are significant risks. Doesn't happen all that often, but once in a while, before I joined CIRSA, I did kind of what Jim did as a city or town attorney for 25 years in private practice for municipalities. So I know it happens once in a while. An employee might come to you despite our commitment to all this and say, psst, can I talk to you about my boss? And our response?
No.
We love and appreciate our employees, but I, as an elected official, and we as a council, don't get involved in personnel matters at that level. I'd encourage you to talk to your supervisor or the manager or HR or someone who can help you with your issue. That's a wonderful place to be because your full-time staff that has expertise with and deals with employment matters, they'll handle that for the organization. They'll take that risk. Dare say they love taking that risk? No, but that's how the system's set up. They'll manage all those risks for you. I know sometimes there are situations that might have more hair and warts on it, right? Like even before you could get my wonderful phrase out, they go, psst, got to talk to you about my boss. He's harassing me. Are we going to say, well, I'd suggest you go talk to your boss? No. Right? But trust that you have systems in place, right? There's already in your personnel manual a procedure for reporting, right, that gives people an alternative to report and then directs the appropriate resources to deal with those matters. So once in a while you may hear something, but from where you sit, you want to unburden yourself of that by reaching out to your manager and then trusting the system where she says, I've got it or we've got it, we'll take care of it as a personnel matter. That's a wonderful place to be. In situations that go off the rails, what I see sometimes is the elected or appointed official ends up being a witness in the employment claim. Not a fun place to be. Never had employment claims where an elected or appointed official, had to be interviewed, have a deposition taken where they came back and said, that was a lot of fun, let's do it again, but the system is perfectly set up to protect you from all that risk, right? Now, at the highest levels in the organization, if it involves one of your direct reports, your primary point of contact would be the city attorney to ask, how does this get managed and resourced, right? Or if it involves the city attorney, then you ask HR or your manager. That's kind of interchangeable if the situation comes up that way. You want to commit to, for your few direct reports, you do want to commit the appropriate attention to that, whatever that looks like, appropriate, timely, respectful procedures for performance evaluations, and so on. I know it can be difficult, but I encourage you to speak with one voice to your direct reports, right? The voice of counsel. When you commit to speak with one voice to your direct reports, that's where you get clarity on what your direction is, and you get accountability, right? And clarity. And the saw from the city and town managers world is they're accountable to the voice of the governing body as a whole. Right? Sometimes it can be messy. Maybe the mayor got an important issue and the mayor got a nice discussion. The mayor says, let's give Sarah some direction. We got one direction, another idea of direction, again, 5 different ideas of direction. That's not what we're going to say, Sarah, have you got your direction? Right? But who owns that issue in terms of resolving it? The council. Right? And you want to own that issue. And in the wisdom of the dark arts that the mayor exercises, he may see, well, this is intractable. We're not going to get there tonight, but we got to commit as a council to come back, right, and resolve that issue so that we can give clear direction. Because it can run the other way too, right? If we just leave it lingering, hope this doesn't happen, but we see it sometimes with other members. The dynamic that unfolds is people may drop by the manager's office and say, hey, that was a messy discussion the other night, but here's what I'd like you to do. Is that supporting the council as an institution, the voice of council? Right? Would one of us be surprised to hear that somebody who was on an opposing view of the direction that we wanted to give the manager was doing the same thing individually? You can see how we're not strengthening the body as a body. So whatever it takes, you'll always get there, no matter how divergent your viewpoints are, no matter how strong the passions are around what the direction ought to be. If we commit to the process of speaking with one voice, you'll definitely get there. Did you have other questions or thoughts
Well,
on that?
no, I'm just trying to think about process. You know, sometimes it feels like you want to check in with the manager first to see if they think you're crazy or if this is even doable before you start saying to your other four colleagues, how do we do this or what could we do?
Yeah.
You know, and so I just, there's a point at which this sounds, and I know this is not a good metaphor, but it sounds like, you know, you're talking about council always coming down to a lowest common denominator.
Yeah.
That if one person's a no vote on something, we all have to come down to respect that, or we all have to have that one voice be as muted and as blasé as possible.
Yeah.
I mean, that's just kind of a feeling I'm getting, as opposed to the type of individuals that people are when they're elected.
Yeah.
To not suddenly go on mute.
Right, right. No, I apologize if that's the sense you're getting. Always be passionate in those deliberations, right? There is that tipping point ultimately in the most passionate debates that ultimately a direction has to be chosen or a decision has to be made. And that's where I'm saying it translates to that one voice, right? We should always, that's, as I said earlier, with multiple member governing bodies, we always want people to be passionate about their viewpoints and have vigorous deliberations. Running towards a relationship with the manager, and I'll certainly ask Sarah if she wants to add anything, is I think it's always your prerogative to make that tactful call to the manager individually if you're needing support or guidance or want to bounce something off of organizationally, what does this look like?
I mean, it's kind of
But-
50-50. On the one hand, you could talk to your manager first and say, I'm thinking of
Yeah.
introducing this idea. On the other hand, you could come in and say, I've talked to all four members and they're all behind this idea and now we're laying it on your desk.
Right.
You know, and so it seems like there's a little more give and take in that
Right.
process.
Particularly on which kind of matters, legislative, policy matters?
No, I'm more policy or direct,
Yeah.
you know, a little bit of anything could be.
Right, right. Yeah, I think, you know, we're going to talk in the transparency piece about talking to the others, right? But I think you're talking about initially identifying priorities and work plan. There's that give and take about where do we want to spend our energy as a governing body?
Or if one of us observes something during the course of the year and it's like, wow, this is really starting to go out of whack, or this is a great opportunity, we should take advantage of it. Do you talk to your council colleagues first and talk them all to agree to it and then present it as a group, hey, to the manager?
Yeah.
Or do you talk to the manager first and say, well, you know, do you have cons on this idea that I should know of that before I talk to my colleagues? I mean, it's kind of like you're prescribing a process that
Yeah.
may or may not work every time.
Right, and it's situational, right?
Okay.
Depending on the issue in play.
Thank you.
One approach may be suggested for that situation and another one for a different one, right?
Exactly.
Do you want to add anything, Sarah?
Yeah, first of all, you're always welcome to call up. You all know also I'm not bashful of saying, great, to get this on agenda because it's not staff-driven, requires XYZ from you, which might mean talking to one or two other council members to get it there. The other thing I would say is that, this is the kickoff, some of the foundational information you need for your updating your working agreements. And that's why we're doing this first, and then we're coming back in about 30 days to go over working agreements and how we're going to do that project. Because it's going to take us 6 to 12 months to complete that project, from my estimate. And so we can break it into manageable chunks. And this is a perfect point that the council might want to talk about is, what does that look like? And what does that look like in terms of this slide is very clear about it, about honoring transparency. So if you're talking to everyone one-on-one versus the public being able to see that conversation in some capacity, how do you manage that effectively and understanding what the limits should be before moving, to get the conversation into the public forum?
Yeah,
Thank you.
thank you.
Yep. Yeah, and I think as you touched on, whether you got a lot of public service under your belt or you're newer to it, I think it's always okay to make that call to the manager to get oriented on potential process, or to the mayor onto initial thought of how council might look at something. But with that, I think it's a good segue to touch a little bit on the transparency piece, because there is a different dynamic in if you have multiple members talking about the transparency piece. I just want to hit on a couple of things quickly, and I'm sure this is a refresher, but you know that as public officials, we're all subject to the Colorado Open Meetings Law, right? Primary rule there is that whenever 3 or more members of the council meet to discuss public business, that's a meeting that has to be open to the public, simply meaning that a citizen has a right to observe the discussion, right? A meeting, for purposes of that rule, includes any kind of gathering in person like we're doing now, by phone, by email, or by other electronic means. So actually, we're kind of doing both today, aren't we? We're on Zoom as well? Okay. So recognize that electronic communications, right, do come into play for the open meetings law, right? That if we're using electronic means of communication, that can trigger the openness requirement as well, okay? Whether it's email or Zoom or what have you. So let's talk a little bit about email, and I'm going to touch on the first handout that I put in my places. In addition to that open records request, just recognize that the legislature, Colorado legislature in 1996, added that electronic means phrase to the statute to make it clear that a gathering that occurs by electronic means can trigger the openness requirement. So if you're using email, you want to be cognizant of that, and that's probably why you've got some systems in place, right? I don't know if it's the manager sends you an email, whether it's, the language at the bottom or common understanding of, do not reply all, so that you're not running the risk of triggering the openness requirement of the statute, okay? Now, having said all that, in email, neither I nor CIRSA are, I guess, what we call Luddites. Is that somebody who doesn't like technology? Yeah. So we're not Luddites. We just need to make sure that we understand there are certain limitations in public officials' use of email. That language was added in the statute in 1996. The state legislature actually didn't jump in to help clarify some of the rules around use of email until last year, right? Because it had to be the case that there are certain uses of email that are going to be okay and that are not going to implicate the openness requirement. And in fact, the legislature last year passed House Bill 21-1025, clarifying that there are certain types of email communications, even if they're among all 5 council members, that are simply viewed as non-meetings, not triggering the openness requirement, okay? So those are things like if the email is an FYI email only, okay? Or if it's emails about scheduling and availability, staff sends out who's available for a special meeting and we're all replying, that's fine. If it's a email responding to an inquiry from a constituent who's not a member of the council, that's fine. So it's only natural, right? If the mayor gets an email from a citizen, but he sees from the email thread that he's the only recipient, he's not sure if any of you got that email, he replies back to the citizen and copies all of you and the manager so that everyone sees that he sent a response. That's not triggering the openness requirement. That's just copying people on a response. Or posing a question for later discussion. Right? Yeah.
And that example you just gave, though, can you clarify when more than one council member responds to that citizen, and at what point does that trigger if they're copying other council members? This is a challenge we have with individual council members responding to constituents. And it's sometimes they're in agreement, sometimes they're not between the different council members, but this is definitely an area we could be interested in hearing what your understanding of that is.
Yeah. In simple terms of identifying the risk, if we're now, multiple people are responding back, but what appears to be happening is a discussion, and we're now directing comments to each other as members of the public body about the merits or substance of some pending matter of public business, that's where we're going to be treading on thin ice related to the openness requirement, right? Mm-hmm. Again, the open meetings law, in addition to setting up those 4 safe harbors that I just mentioned, the other thing that the statute did was emphasize or restate that any discussion of the merits or substance of a matter of public business, right, is subject to the openness requirement. And so it's kind of intuitive, right, in thinking of, well, that deliberation that we as a council are going to have on that matter, we want that to occur in this room, right? Even in legislature, bless them, was nice enough. You go, well, what does it mean to discuss the merits or substance of something? They drilled down a level deeper and said, well, merits or substance of something means when you're discussing the essence. It's like effervescence or something, right? What is that? Right, but you intuitively know when you're treading down that line. The overarching policy statement is that the formation, right, of public policy is public business and shall not be conducted in secret, right? So those council discussions where you're debating the merits or substance of a position to take or a decision that you need to make, those are the discussions that are subject to the openness requirement of the statute, right? And that's where you want to commit yourself. You see on the email thread that it looks like, even though this started as one of us responding to a constituent, if my response is really intended to give information to another council member about my view of some issue, yes, it was related to that citizen's inquiry, but it's also part of a larger discussion that we're having as council. I think you want to put the brakes on it and say, let's save that discussion for when we're together in an open meeting. Okay?
This, for me, is a really gray or nebulous area. Email threads can get really complicated.
Yeah.
You know, you reply to all, you reply to one, and they reply to all.
Yeah.
Do you know of communities that have a tracking system that helps to sort that out?
I haven't checked in a long time. I think the city of Boulder at one point, they might still have it. They tried this technology that allowed all council member emails on city business to be put up to a accessible site where in real time you could see the email. It does plug into the legal risk a little bit, but the question that's going on there is, I think, they kind of got pushed back of saying, well, if there are substantive discussions going on about issues of interest to me by email, and yes, I can see them in real time, but does that mean I need to be monitoring that website all the time so I can keep track of what's going on, right? I had in the physical space, I suffered the same criticism of, like with notices, some communities will do this, what they call a sunshine notice, and they'll post notice of every potential gathering you'll ever attend, whether it be 3 or more of you, right? And, oh, you're going to the Chamber of Commerce dinner. And the criticism of that was some constituents say, does that mean I need to go to the Chamber of Commerce dinner if I need to make sure that the council's not discussing my issue that night, right?
Yeah, I don't want to sideline the conversation, but it's been a concern, I think, of all of us to some degree throughout. Sometimes the replies will be hidden within a thread, and you think you're replying to the response, and email threads can, and depending on what your client is, but Outlook's kind of a beast anyway.
Well, and it looks different after the fact, too.
Yeah.
Right, when people, they make their core request, particularly on controversial issues, they make the core request, they examine the threads, not only for content, but for who's copied and who's not.
Yeah.
Right, and so at the slightest whiff that there's 3 or more members of a body engaging in a discussion, and the thread seems to show that, then there's this, potential aha moment where the person feels like, oh, they've run afoul of the openness requirement, right?
Right.
That may or may not be the case, but that's one of the risks, right?
Yeah. I think we saw something during the pandemic that was a little tricky for all of us, and that was that it came from citizens. It wasn't communications, and it was an email list of probably 60 names. And so it was asking us about, pandemic relief, but it was going back and forth. Is it too much? Is it not enough? And all these different people so it became a huge thread, but obviously it wasn't appropriate. None of it was quasi-judicial work, but it was, just got messy. And you just didn't even realize, they're asking for us to respond,
Right.
but then you can't, because they're asking all 5 of us to respond at some level in this email chain.
Yeah, and it's a deliberative process.
Yeah.
So just doing it by that email, right, it kind of takes away from the space that you need to collectively occupy. I don't know if this is true or not, but if that discussion related to some governmental resources, maybe some city money or city support for something, right? If you break that down, you say, wait a second, is this, as I mentioned earlier, is this a council matter? Why are we involved in this? If it's a bunch of emails about some decision the council has to make, that's when the radar goes up and says, oh, well, let's let's stay away from the email discussion and agendize it, as Sarah
Yeah,
mentioned. For a discussion point.
it was just kind of very pressure-oriented.
Yeah.
And, when you don't respond, it's like, hey, you're not responding to 65 business people who are very concerned about this right now. And so it became, a mess, so we appreciate the guidance.
Yeah, failure to respond is a response itself, right? Particularly in this day and age. Yeah. Yep. Any other thoughts on how we manage that stuff?
And that's one of the things I have on the list that I know the council wants to dive into a little further, and that's where giving staff permission, i.e. me, Diane, to respond on behalf of the council, and we can include in there why you can't respond.
Right.
And why we're doing it on behalf and how they can engage more effectively. But that's something that the council has to agree is an acceptable response. So that'll be a follow-up conversation for us to have in these rules and regulation updates. Thank you.
Yeah, and if the emails are either unintentionally or sometimes on controversial matters, people will do it intentionally.
Yeah.
And you end up with this telephone type of situation where you're not sure if your colleagues are getting it or what their response is. And then as Sarah hinted at, we haven't had this time. You've been deprived of your opportunity as a council to have that discussion about how do we want to respond or what's an appropriate response. If you've already had a little bit of a discussion around that, I guess one of the things you can also do is use your manager, right, of course, as a resource to help run interference for you. If you've already identified a message, an initial message, when those come in, they'll, I got your email, you can touch base with our manager and she'll give you the information on the current status of this or that initiative, all right? Okay. Who's active on social media?
Pardon?
Who's active on social media? Won't get in trouble with CIRSA, I'm just curious.
Historically very active, taking a break.
Really, I was going to say.
I haven't, no,
Yeah, you're the most,
like seven months, I haven't read a thing, maybe 8.
So I just want to touch on it a little bit. It's, there are some risk issues to it, of course, right? Do we all have personal social media sites?
Personal.
And they're personal?
Yeah.
Nobody ever contacts you about city business there?
Oh, no, they do.
They do? Okay.
We're dartboards.
Do you all have city-issued email addresses?
Yes.
yeah, we have
Okay,
city
we have
email.
official social media sites for the city? Okay. So there's this developing body of law that it's clear for First Amendment purposes. Remember, as governmental actors, we cannot discriminate against individuals for speech based on their viewpoint that they're expressing. There's a body of law around this now that says that that's going to apply even to a public official's individual social media site if their individual social media site is governmental in nature. There's a whole bunch of factors that can be looked at and decide whether or not it's governmental in nature or not, right? But it's a pretty fluid analysis, and admittedly, we don't have a 10th Circuit decision directly on point here that controls Colorado, but staying at the 40,000-foot level, the takeaway is that if your social media site is something that you use to do your job as a government official, then you ought to assume that it could be subject to First Amendment principles. Main takeaway that you read about in some of these headlines that I put here is, if that's true, if a court decides that it's true that First Amendment principles apply to your social media site, then obviously do not block users or edit or remove posts or content based on the viewpoint of what's being expressed. Now, having said that, you don't have to have the comment feature on at all. Mm-hmm. That's one content neutral way of dealing with comments, is to not have the comment feature on at all. But if you do have it on, and if your site is in fact governmental in nature, and despite your best intentions, you want to put out something positive about the city, but the first thread that you get in the responses is some snarky comment, and oh, you're all crooks and liars and this and that. Well, we're just going to let that one slide. It's going to roll off, right? There is a very small, limited exception to the types of speech that can be regulated, obscenity, incitement, true threats that I'll talk about in a minute. But other than that, recognize that if we opened up that conversation and we allowed people to comment, then it's essentially come what may.
You can't remove the comments, is what you're saying.
Do not remove the comments. Take solace in the fact that I think the last time I checked the statistics, there were more than 300 million social media posts per day. So the comment that seems impactful and explosive in the moment, that's going to fall down the thread pretty quickly and be yesterday's news before we even get to the end of today. So you just, but if that's what you're doing on social media, engaging about city business, there's a risk that your site might be governmental in nature. Now, if you don't want that, keep your personal site personal, right? Don't use any trappings that help suggest that it's a public official site. And for constituents who knew you, you knew them before you took office and you still know them, when they direct message you about city business, if you want to keep your personal site personal, you could say to them, hey, DM them back and say, hey, next time you want to chat about city business, why don't you email me at this official city email address? Mm-hmm. And that'll keep the two baskets separate and help you maintain that line, okay? Yeah.
I don't think I really understand. So would I would think the First Amendment would apply to any social media, not just if you're using it for some modicum of government stuff. So you're pointing that out here because some people think it wouldn't apply to them? I guess I don't understand.
Yeah, well, you're governmental actors. So, yeah, private actors have a right to discriminate if they like. Governmental actors don't with respect to free. That's probably the most simple articulation of free speech ever. But, yeah, as governmental actors, right, we don't have the right to discriminate against individuals based upon the viewpoint unless there is substantial interest or some other legal tests are met, right? So you do hint at, if you want to take a second to go a little deeper down the well. Okay, so there is, again, there's no federal 10th Circuit case in Colorado that clearly answers the question of when does a personal social media site of a government official become governmental for purposes of First Amendment liability risk. The risk being as a governmental actor, right? If you deprive someone through state action as a governmental actor of their First Amendment rights, then you're at risk of a civil rights claim, okay? So that's the risk. We don't have a clear decision on when a site becomes governmental in nature, but we do have some case law around this. And one of the cases that involved former President Trump did rule that he had potential civil rights liability because he blocked a user who was critical of some content posted on his official social media page. That went up to the U.S. Supreme Court. The U.S. Supreme Court said, we're not going to look at this case because he's out of office, so we'll view it as moot. In a concurring opinion, doesn't have any legal weight, but in a concurring opinion, Justice Thomas raised this question. He said, well, isn't it interesting that governmental actors are subject to First Amendment principles when they use social media, but they themselves are subject to this overarching right of the private companies that run these social media platforms to shut down their account entirely? So that's a question that's out there. I think Justice Thomas is trying to hint at the question that he would like the court to take up at some later time. So they're not there yet.
Yeah.
Okay, but there's more to come in this area. Best we can tell you from our risk management standpoint is don't block users if you have the comment thread on, and don't edit or remove comments.
Right. You just want us to hear that we should not feel that we have any right whatsoever to restrict speech of anyone if we're on a platform.
Yeah, don't unfriend somebody because they made a comment.
Got it.
If it relates to public.
If it relates to.
Yeah, if they didn't like your barbecue, then hey.
That's okay.
Then it's okay. But I mean, so I want to be sympathetic.
Statement of America.
I want to be sympathetic to exposure that runs the other direction, because maybe you agree with me that sometimes public officials and public employees, right, can be on the receiving end of some less than courteous comments on social media, or maybe even snarky, or maybe even threatening, right? So there is a body of law around the concept of what constitutes a true threat in the virtual world, including a developing body of law about what is a true threat against a government official, right, for which the government can potentially take action. Under the current law, just to keep it simple, essentially a true threat is one that puts the intended recipient in reasonable fear of imminent harm to themselves or to someone close to them or someone in their household. It sounds like a pretty scary and close line, and it is, intentionally so. in service of free speech. But I just want to let you know that principle is out there. If ever that happens to you, a couple of risk management pointers. First, don't gainsay your own perceptions of your own safety. If you feel unsafe and that you're under threat of imminent physical attack or something like that, don't say, I'm going to ignore it, right? But get appropriate resources. You can call your manager, your city attorney. You can decide whether or not law enforcement needs to get involved. It may or may not, depending on the circumstances and the context, may or may not run afoul of some criminal statutes. Okay, our Supreme Court a couple months ago did strike down a portion of Colorado's harassment statute intended to get at online harassment, so it's a little more difficult in terms of criminal prosecution. But if you're feeling like this person's making a physical threat against me or a family member, some of these folks know exactly where the line is, and they get awfully close to the line, right? But that doesn't mean that you shouldn't, get some resources to figure out if there's something that can or should be done, and staff can help you with that, okay? The other thing, maybe not so much that kind of risk, but sometimes you're on social media and you read something about there's comments in there about the city, and it's just blatantly wrong. You're like, that is so frustrating, right? But before you, think about who should respond, if at all. Maybe no one should respond. That's just what goes on in the social media world, right? But maybe if it's something where some correct information would help everyone, including people who are opposed to whatever the city's doing. Maybe you touch base with the manager, they look at it, and maybe somebody just retweets or puts on that social media thread a link to the city's official social media site where you can find more information, that kind of thing, right? Hard to manage.
I'm just thinking about the job of correct everything wrong
Yeah,
on social
you can't.
media.
You
Good
can't.
luck.
I think they're already doing it.
You can't.
They're on it, aren't they? Facebook's got
Being taken care of.
You can't. There's in this handbook a chapter with more stuff about social media that I hope you find helpful to you. Yeah.
Just on the top point, recognize risk, at the end of that, it says tort claims. I'm
Yeah.
just-
What type of tort claims?
No, it says tort claims.
Libel, defamation, that kind of thing.
Tort.
Oh, I'm sorry, tort.
Yeah, I'm just not familiar.
Sorry, a tort is a civil claim for money damages
Thanks.
other than a breach of contract. So it's that whole basket of every other way you can sue someone for money damages for personal injury. In the social media world, it's if potentially you step over the line and you defame someone on social media, they may think they have a defamation claim against you. Yeah. So,
Thank you.
yeah. Yeah. It's two things that are self-evident. When you're in campaigning mode, you can't use the city's official sites for any campaign purposes. Just to give you a sense of the landscape, among our members, almost all of them have social media policies that apply to staff and staff's management and use of official municipal sites. Not that many have social media sites that touch on the elected or appointed official level. So it's something to think about. May or may not be necessary, may or may not be of interest to you, but there are some cities that do have that. And probably the way it relates to your work is that since you don't have official individual accounts, probably the primary provision I've seen in some of those is if you're talking about city business on your personal social media site, are you taking steps to confirm that it's only a personal viewpoint, right? And that you're not speaking you're not speaking officially for the city, right? That kind of thing. Maybe you are, but if you admit that and maybe you are, then you're going to, then we may have a governmental
And it
site.
needs to be on the city site,
Yeah, right,
not
right.
your site.
Actually, I do have a clarifying question. So, when I stepped off social media after like a cold turkey break, trying to figure out how to rebalance being in communication with citizenship, but not supporting this toxic environment. So I've been testing out the email newsletter, which is one of our formal council members did. And so do the same things apply to an email newsletter from you also can't remove someone from the list if they're doing, okay.
You're stating your position on public policy matters. That's what's fundamental about it, about where it goes from personal domain to public domain,
Got it.
where you would want to take these precautions. Always err on the side of expression unless it reaches one of these extremes that Sam has described of personal safety. And like in the cities, you can even, if you're interested at some point, check the city's social media channels. You can click and see our rules. Like, we have a very small but clear set of rules that if you violate, we will remove or hide your post. And it's like, vulgar
Obscenity.
language. Yeah. It's one thing to say, Sarah's a fluff, but if you want to use a more explicit term, then it's not going to happen. It's going to get flagged by the system, yeah.
I don't think you're fluff, whatever that is.
What can I say that's not obscene?
Yeah, from a citizen potential claimant perspective, right, when they're interacting with you, their presumptive way of looking at it is this is engaging with a public official on a matter of public concern, maybe a public forum by electronic means, right? If you send the email out and people are responding to you back, they'll probably think of that as saying, well, I'm petitioning my government for my grievances, or I'm engaging in public forum discussion with an elected official, and those are all protected forms of communication with electeds. So.
And they're not.
I've been involved in IT for several decades, and when the internet first started, there was an argument about censorship of sites. And if you censored something, then you would become responsible for censoring everything or filtering everything. So a lot of sites just said, we're not even going to go down that road of censoring. We're just going to allow it. Now, Facebook and other companies are trying to decide if it's a real person behind the account, what the truth is. And so we've come a long ways as to what social media does and what can be censored, and perhaps what Justice Thomas was talking about high level of censoring a person's whole account.
Yeah. All right, before I pivot over to ethics, any final questions, thoughts on open meetings, transparency stuff?
Just for the benefit of the public that may be listening to, is that social media policy for the city also has an appeals process. So it's not an absolute. There is a way you can come and someone can file an appeal with us to say, no,
She really
you
is a
used the
fluff.
incorrect. Yeah, you use the incorrect criteria for judging my competence or whatever.
Okay, fluff
Yeah.
definition.
Thank you.
Yeah, or the way I intended to use that word had some actual
Luminous hair.
contribution to a discussion of a matter of public concern. Okay, let's talk about ethics real quick. So we don't have all that many ethics scandals in Colorado local government, right? I
Not
think
really.
that's a great,
There's a few.
there's a few,
One continuing.
and they're pretty exciting to read about, they kind of, when they don't involve us. As the municipal guy, I kind of enjoy reading about, ethics scandals at the state legislature or something like that. But, more seriously, you're all subject to the city's code of ethics. As a home rule municipality, you have that option under the Constitution to have a local code of ethics and have your own local enforcement mechanisms and your own local gift rules and so on and so forth. So that's where you want to look. I know that the ethics code is written in a lot of legalese, right? And it's got a lot of wiggle words in it and so on and so forth. But you want to take the time to plow through the code of ethics and get a good working familiarity with what the expectations are. And staff probably has other resources or guides that they can help you get a good working familiarity with what the rules are. Even to the point where I say, I dare say, make it your best friend in dealing with ethics issues. You go, wait a second, it's a bunch of traps. How can it be my best friend? Right? If we have a good working familiarity with the code of ethics, we're prepared for a couple things. First, that enables us to spot issues early and deal with them, right, in advance before they become potential problems or worse yet, actual violations. One of the things that I regret most is when I deal with and try to help give suggestions to an organization where an elected or appointed official already committed the violation, but said, I didn't know that's what our code required. You go, well, it's that Hemingway thing of the bell is tolled, right? And you can't unring the bell, you know? And so want to get a good sense of what the rules require so that when we're looking at advanced agendas or dealing with some situation, we have our radar up to say, oh, wait a second, I've got a potential attachment to that issue in a way that implicates our code of ethics, so I can get some resources, think about what I need to do, and what my obligations are in that regard. So ethics can be a training in and of itself, but I'll just quickly touch on 4 key principles. Of course, you know that you have a conflict of interest rule, right? And we all know the basic concepts of that, right? And a conflict of interest is basically whenever council's going to take some kind of action that affects our own personal financial interest, we're in a conflict situation. We have to declare our conflict, right? Recuse ourselves from the council discussion and vote. I think you have to leave the room, is what your code requires. And you have to refrain from attempting to influence the other members of council. Easy enough. You know, interest includes not only your own personal interest, but derivative interests, relatives, business entities with which you have a relationship, that kind of thing. So keep your radar up for those. There are other types of interests that come up for quasi-judicial matters. I think you have a bright line rule, right? That if you're 300 feet
Oh, yeah,
or less.
for,
Yeah, so you've, it's a nice bright line rule. That's good for you. Some members ask, you know, well, there's no bright line. But you have a local bright line rule on that. So pay attention to derivative interest. Then once in a while, the question comes up, and it's more about the appearance issue. Maybe you don't have an interest, actual financial interest or other prohibited interest as defined by your code, but there's this group out there that perceives that you have or believes there's some apparent conflict or perception of impropriety. What do we do in those situations? What do you think?
disclose and make the choice after speaking with your attorney if you want to proceed.
Yeah. Yeah, and I think that's good. You know, if we get on the record, if we know that there's some people out there watching that think I have a conflict, right? But in advance, I had my radar up, I analyzed it, I talked with the city attorney, understood how the code worked, but I can tamp down that issue by making what I call kind of a curative disclosure on the record. Right? And say, I just want to, before we start, Mayor, I want to speak to a question that came up under our code of ethics. I know there was some assertion that I have a conflict in this. Just want to make it clear that I don't have any prohibited interest and so on and so forth, and I intend to decide this matter based on the criteria that apply and so on and so forth, right? And that can be helpful to you. Sometimes there's a purely personal interest. The applicant is your friend. Everybody knows the applicant's your friend. What do we do in that situation? You can do the same kind of thing, right? You don't have
Share
to.
the friendship.
You don't
and
have
say,
to, yeah, but you don't have to, because it doesn't implicate the code. But you could, by the same token, say, I just want to clear the air on something. You know, the applicant here, yes, they've been a family friend, but we're just acquaintances. I have no connection to this. I'm going to judge their application same as every other one. And you have to believe it, and you have to walk the walk, and if you do, you should be fine in that regard. Okay. You have some gift rules in your code. Just check out what those are. My takeaway on gifts is timing and context matter. And that's probably the biggest factors in determining whether a gift was appropriate or inappropriate. Yes, there's a long list of exceptions, and there's in your code a definition of what a prohibited gift is. Take a look at those. But it's the best way to manage that risk is to just understand what the core rule is, what the exceptions are, and then think about gifts in terms of timing and context. We all have relationships and folks in the community that we interact with, and lo and behold, some of them are our business associates and colleagues, not in the terms of having an actual financial tie, but we know them in the community. But lo and behold, they're the ones with an application in front of council next week. Well, that's not the week, right, that we're going to go to the ball game with them or accept a fancy dinner or something like that. We're just going to tell them no thanks. Okay? All right. Unless there are any questions about your code of ethics, I just want to turn the page and say that compliance with the code of ethics, I think, is it's one thing, right? But I think in terms of strengthening, in particular strengthening the council as an institution, right, go beyond ethics. right? And think about norms of personal conduct in recognition that, inappropriate personal conduct can be destructive to a public body and its agenda, right? May not always translate into third-party civil liability risk, but we see these issues every once in a while at CIRSA because people will call myself or our executive director and say, hey, we have this conduct issue going on. Does CIRSA have a rule that applies, magic wand that'll fix this issue, right? But there's no such thing, right? But it's a wise counsel that if they have these issues going on, they spot them, and it might be a difficult discussion, but they find ways to try and work through them in terms of strengthening counsel as an institution, right? Wherever it's coming from. My last substantive commitment here is committing yourself to due process. I know you handle a good number of quasi-judicial matters, so you know kind of the basics of all that, right? But recognize that it's a fascinating job because sometimes you're just legislators making policy, but other times you're deciding specific applications that affect someone's individual protected property rights. And that's the quasi-judicial role. And we know it. It's where we have extra notice, right? We're going to have a mini trial in front of council where you're the judges, right? And that hearing is one where everybody comes in front of council and puts in their information. And you're, as the judges, required to base your decision on the existing standards that are in place and only on the information that you receive at the hearing. That all sounds like a judicial proceeding. And it is. It's just called quasi-judicial because they didn't give you robes. But it's part of the job. You can get robes if you want, right? But that's the nature of the job.
Rachel could use one.
Yeah. And it's kind of the,
That was a cape.
I'm also into capes.
it's kind of the counterintuitive part of the job. Because when you think elected official, like a policymaker, I make policy and I deal with the community and the constituents, but there's this other part of the job which is more restricted in the box in which you operate. And all the millions of pages and hundreds of thousands of decisions around this issue, it all boils down to, where do these different rules of engagement come from, right? No person shall be deprived of life, liberty, or life, liberty, or property without due process of law. That's what it's all built on, right? So this could be a separate training in of itself, but I just want to touch on a couple of tips that seem to be common themes that reoccur in staying out of harm's way in quasi-judicial matters. First, just like a judge, you have to limit your involvement in quasi-judicial matters to just the council's public hearing, right? So I know that's a lonely part of the job because the rest of the world knows controversial development application coming up in 2 weeks on council agenda. What's the citizen's natural inclination?
Talk to you.
I want to call up my council member and tell them why they should vote yes or no, right? In the legal world, we call that an ex parte communication. That's a communication with the interested parties outside of the hearing. You have to stay away from those, all in view of ensuring fair process for everyone. It really is analogous to just like if we were in civil court, right? If we were in civil court and I owed you money and you got tired of waiting around, you sued me, tomorrow's our trial. Your expectation, your right under the due process clause is that I'm not on the phone with the judge the night before, right? Judge, how's it looking? You're going to rule for me, right? Same concept applies at a local government level. It just seems a lot squishier, but it's the same concept. So limit your involvement. I know that people will email you or call you, have whatever tools and tactics you have to remind them. It's not that I don't want to hear from you. I'd love to hear from you, right? But I can only do that through our hearing process. So if you come to the hearing if you can. If you can't, you can send in written comments to our staff, and I assure you that they'll become part of our hearing record, and we'll get a chance to look at them, that kind of thing. The other job of a judge is the decision has to be reached by a fair and impartial decision maker. That's all of you. All right? So you don't make any prejudicial pre-hearing. You all regulate marijuana, right? Mm-hmm. Are you the judges, or do you have a licensing board? You have your own licensing board? I'll tell you kind of a fun war story. I don't know if you got to the marijuana regulation business by ordinance of the council or by vote of the people, right? But we had some members who the governing body prohibited it, didn't want anything to do with it. And then by initiative, they were required to regulate it, right? Well, we'd have these public hearings on a new marijuana license, and the week before, the governing body member would say, well, I'm never going to vote in favor of a marijuana dispensary in this town. You can't do that, right?
Just recuse themselves.
Yeah, they at least created evidence of, the legal standard is you have to basically demonstrate that you don't have an open mind to hear the evidence that's going to be presented. So you want to stay away from that stuff. Of course, if you have a conflict of interest, you need to bow out. We've covered ex parte communications, and coming back to your comment about deliberations, all right? And I think when you get to deliberations, that's when, they've heard everybody's evidence and the mayor brings it back and says, let's talk. That's the point in time to dust off those criteria. You may even want to do it earlier. I recommend that if you have some way to have the standards or criteria available for members of the public, put them on the screen or have extra copies of the staff report, it helps recalibrate everyone to what's under discussion, right? Because sometimes it's that ship's passing kind of thing, Maybe the only thing on the agenda is the final development plan, like for multifamily or something, and that's all you're really deciding is final architecture and parking and landscaping, but people stand up and go, this property should have never been zoned for multifamily. I was like, well, that ship has sailed, right? But having the criteria readily available to everyone gets everyone, and that empowers the people who are going to speak too.
Yeah.
When you say to them, this is what we're deciding tonight, it'll really help us make our decision if you, as the audience, focus on these issues, because that's what we're talking about tonight, landscaping, architecture, so on and so forth. But when you get to deliberations, you want to have those handy. And I say use Sam's rule of why. Sometimes it's a rocky start. Sometimes mayor says, well, who'd like to start? I'll say, Mayor, I'm going to vote against this final development plan because I don't like it. Well, it's okay start. But you can get there just by, probing each other on, well, Sam, why don't you like it, right? If I offer some off-base, I don't like it because they didn't agree to put X dollars into our community grant fund. Well, staff's going to raise their hand and say, well, just a reminder, that's not an applicable criteria or standard for development plans. But if I say, I don't like it because it's too tall. Oh, well, maybe that was the crux issue. And the whole staff report speaks to height and the variance they're requesting for height, right? Or maybe it's even more nebulous. I don't like it because it's incompatible with the neighborhood. By the way, that's a legally enforceable standard, right? But what we want to do is make a good record of why it's incompatible with the neighborhood. So you just keep testing each other. Well, council member, why do you think it's incompatible with the neighborhood? Well, because it doesn't meet our design standards, right? And it's got some strange architectural materials that aren't allowed under our code. Now just by that discussion, we're making a record of why we're going to take the action that we're about to take on that application. So recommend to you, make sure that every member of the quasi-judicial body has a chance to speak, whether they want to take that chance or not. And when you do, just speak to the criteria. I'm going to vote no based on these criteria, or I'm going to vote yes because I think these criteria, are met. And you'll always get to a great spot there. Yes?
I have a quick question about ex parte communications. Because on one hand, it seems like let me give you a hypothetical. Say we had an important issue coming up and I ran into somebody skiing and I'm riding a chairlift with them and they tell me a piece of information that I'd never heard before about this issue coming up.
Yeah.
Do I just stop the conversation immediately, or do I say, you need to come before the whole board and present this information? Or can I take that information and bring it to the board myself? What's the correct path forward?
And I'll turn to Jim if he wants to add anything, but a couple things. Once you know that they want to talk to you about the issues under consideration for a quasi-judicial matter, just tell them you can't pivot. Whatever it takes, you pivot to try and head that off. And then you can remind them, look, I can't engage with you, but there's a time and a place, and we'd love to hear from you, but I just can't do it. One thing that I've heard feedback from elected and appointed officials I work with, is they tell me that this one seems to work pretty well, that if you tell them, hey, if it were your application, would it seem fair to you, that maybe somebody opposed to your application was talking with one of the decision makers without you being able to hear what they were talking about? That wouldn't give you the chance to respond. Does that seem fair? And so that can kind of build, and if not, then you maybe have your earpods with you or something, or hopefully it's one of the shorter lifts or something like that. Now, the other thing that goes on is, what do I do with this information now that I have it? I will tell you, in my 25 years of counseling quasi-judicial decision makers, I didn't really ever get to too many ex parte communications that were like the crux matter. But I think a good thing to do is call Jim or the planning director, planning staff, talk through with them what you heard, and they'll help you decipher whether it's something where we need to make a disclosure on the record. I used to give an example in my quasi-judicial trainings of, let's say it's a hearing where you've already had one session, and the crux issue is the criteria that says the property proposed for development cannot be critical wildlife habitat. And that's in our ordinance. Applicant testified, it's not. Staff said, yep, we did our study, it's not, right? But you, with this person on the chairlift, and maybe even with your own eyes, learn that actually it is critical wildlife habitat. And that's important to you, because if it is, you might vote no, right? What are we going to do with that? So you can just get it on the record. But what you want to do then is pivot and get it on the record, and then don't become a witness in your own hearing, and exercise your right as the decision makers to require people to bring you information. You always have the prerogative to ask questions. So in that situation, you could disclose on the record, maybe before we start, I need to disclose an ex parte communication. Right, I was out and talked to this person, and they asserted that it's critical wildlife habitat, and they even said they saw it with their own eyes, or I saw it with my own eyes. So I want to get that on the record, and therefore I'd like the applicant and staff to speak further to that issue. And you're off to the races from there of getting it back where it needs to be. So does that help?
It
Want to
does.
add anything, Jim?
Not really. We do face that situation a lot, or you guys face that situation a lot, particularly when you're riding on chairlifts and people just keep talking. And I do encourage you just to come to me, and then we'll figure out where to go with it. But usually the solution is to just state at the beginning of the hearing that you've had this person made these statements, just as you were saying, and we take care of it, and it becomes fine and becomes part of the record.
I've absolutely used the technique you described by saying, I just can't talk to you about it, be quasi-judicial. I literally, you'll need to disclose this phone call that you had reached out to me, and then say, but take heart that I'm not speaking with anyone on either side of this issue, and please come to the public hearing. But I think it is important to kind of keep in the back of your mind the other, quote, definition or sense is if you've heard anything that is potentially going to influence your vote that was not said publicly in the meeting, you need to disclose it. And even if somebody just shouted across a football field at you, and you tried not to hear it, but it's influencing you, you need to disclose it.
Yeah, that's a great suggestion. Yep. Yeah, and it has that curative effect. Because the whole point of the due process clause is just to get that on. The whole idea is to have a hearing where all the interested parties can hear all the information that's relevant to your decision, and they can respond to it. And then you're in a good spot. That's just part of that grand bargain. At the end of the day, only 5 people in the community have that ultimate power to make that decision of whether that decision, that application gets approved or denied. So we just need to self-police on that, be conservative, if you have to make disclosure, it probably happens pretty quickly, right? And you get it on the record. And in my world, then once it's on the record, and if there's no evidence challenging that, that's a good thing to have in the transcript, right? And it just makes all those assertions that something was, poof, that goes away, right? Any other questions about quasi-judicial stuff? Just to wrap things up, so my last suggestion is to commit yourself to wise leadership. We touched on some of these points before, but as a council, in dealing with each other and in dealing with staff, commit yourself to a no surprises approach, right? Meetings ought not to have kind of that gotcha sense or surprises approach. As we know, as you know from your familiarity with personnel matters, public meetings should never have that staff bashing sense, even if it's, if it's a citizen stands up during public comment and makes some comments about the staff, then I'm sure you have tools to recalibrate and say that we don't go there. That's not what this council's about. Commit yourself, as I've touched on in earlier slides, to dealing effectively with discord, wherever it's coming from. It's only natural that you're going to have disagreements, but people can have disagreements without being disagreeable, and right, you don't want that to drive your agenda or how you interact with each other or the community, no matter how much people may want you to do that, and that's the social media pressure, right? That pressure to be disagreeable. I don't know where all that incivility comes from, but I think social media is an influencing piece of it. I think maybe this elected officials tell me that there's a definite trend of incivility at the state and federal level about how those issues get worked. It's filtering down into local government, but you don't have to let that influence how you do your work unless you want it to, and then you just have to be prepared to deal with those things that come up.
Seems to be worldwide.
It is, it's worldwide.
Yeah.
It's worldwide.
Yeah.
We, a little side comment, at our general membership meeting for CIRSA at Breckenridge a couple weeks ago, I did a presentation on incivility that's posted on the CIRSA website, and you can look at the slides there if they're of interest to you. But in that world of incivility, do recognize, and I know it's tough, that, but it is true that tone and temperament matter. In certain situations, certain types of risks, not many of them, but certain types of risk, the risk exposure, it does get influenced by the sense of how it went down, particularly in the civil rights retaliation world, that there's some whiff that the government overreacted or acted out of improper motive, then that's when a claimant thinks that they've got a decent retaliation case. So you always have, from where you sit at the dais, the power and right to define the approach you're going to take and the tone and temperament you're going to use. So use that to your advantage and to always be in a good place. So finally, tying up to my earlier slides, recognize always that you're the fiduciaries and ambassadors of the organization, and always keep in mind that you're the stewards of the city's best interests and assets. So with that, I'll open it up to any questions. There are some resources, more resources from CIRSA listed on one of the slides there, and I'll open it up for any questions you have. And Mayor and Council, thanks for inviting me up. Staff, thanks for having me come up. Wonderful to
Thanks for coming.
get out of the metro area and come visit you all.
Were there any major legislative changes this session that would affect operations or how we conduct ourselves that you're aware of?
I can't think of any off the top of my head at the elected official level. There was a late attempt to do some things with the open meetings law, but that got shelved.
Okay, I'm just wondering.
No, not that I can think of.
Could you comment on serial meetings, decisions made during serial meetings, Douglas County School Board, et cetera?
Oh, sure.
Email chain.
Yeah, so going back to the rule under the openness clause is that whenever 3 or more members meet to discuss public business, it's a meeting that has to be open to the public, right? So implicit in that rule then is one-on-one discussions are okay, right? You do want to be cognizant of the point of, when I say one-on-one, yeah, it's only 2 members talking, so that's fine.
And if it's non-quasi judicial?
And if it's non-quasi judicial, yeah. So I described it, one-on-one's okay, but let's think about this concept. What about one-on-one on one-on-one on one-on-one on one, right? Well, it's going to be kind of an it depends situation, right? We don't have a lot of case law in this area, but I'm going to touch on the Douglas County case in a minute. If evidence comes into a case that suggests that the action that occurred at the public meeting was what courts have called a mere rubber stamping of a decision that was clearly made outside of the open meeting requirement, then that's when you run a risk, right? And we don't have a lot of cases in Colorado speaking directly to that issue. And I think the reason why is it speaks to the commitment that our elected and appointed officials have to honoring their obligations for transparency. So that's the risk. Okay? The Douglas County case, what's being referenced here is there any risk to the idea of one-on-one on one-on-one on one? The Douglas County case involves the Douglas County School Board. And I need to make a disclaimer here that my comments are going to be based solely on what I understand to be the allegations in the complaint. Okay, so I don't know where this case is going to go, and it's in the early stages. But this kind of illustrates the potential risk profile. As you know from the news, I guess the Douglas County School Board
Newly elected.
newly elected, the makeup of the board, but I think that's been that way a couple of election cycles. I think it flipped back and forth. So they had an election, and they had some new members come on, so now there's a new majority, 4 members. And the allegations in the complaint were that the new majority, the 4 members, met one-on-one, discussed the retention of the superintendent outside of an open meeting, and essentially determined that the 4 of them, that's what they wanted to do, was terminate the superintendent, that the votes were there. The other allegation was that 2 of the members went and talked to the superintendent and essentially said, well, the votes are there to terminate you. Would you rather resign or be terminated? So does that sound like a decision was made? Right? Does it sound, is the decision to terminate or retain the superintendent one that the board makes? Absolutely right. It's subject to their official action. So those were the allegations in the complaint. The trial court has issued a preliminary injunction on those facts, saying that if those facts are true, then that sort of behavior would run afoul of the openness clause. When members got together, even the claimant said, I'm not saying that 3 or more members met. I'm saying that one-on-one on one-on-one, they all decided how they were going to make a decision that was subject to official action. The takeaway really is, remember, not only in the openness piece, but the statute says any kind of action has to occur in an open meeting. So that's what's in play in that lawsuit. I'm not sure how it's ultimately going to shake out. No. One other thing on this, just to give you a sidelight, is this is an area where I want to be cautious and cognizant of that potential risk. There is the statute in Colorado doesn't speak directly to one-on-one meetings or the rubber stamping concept. Some other states do. In Texas, they call it the walking quorum rule, which I thought was always a great phrase for Texas. They've actually been going back and forth in Texas about an amendment to their open meetings law that basically says it's a misdemeanor to violate the spirit of their open meetings law through a conscious course of intended one-on-one meetings that are intended to replace public meeting discussions. So the reason I mention that is just this is an area where we want to be cognizant of the risk and be cognizant of honoring our commitment in view of controlling our own destiny and not have the state legislature write the prescription for us, because, there's a risk that it could be heavy-handed. Limit your flexibility, right? Do things that aren't intended to occur, because part of the job is having one-on-one discussions. But there's a recognizable distinction between having a one-on-one discussion and doing so in view of supplanting or replacing a decision or a discussion that has to occur in an open meeting. And you intuitively know where that is, right? Whenever you want to discuss the merits or substance of a matter, you want to do it collectively. So.
Council, I just offer up as an example is if it's a matter of figuring out, do you want to spend some time on an item on an agenda? That's not a serial meeting in my eyes. It's figuring out, is this an agenda item that we want to bring for public discussion? What I would encourage you always is to err on that side of transparency. If you're even questioning this at all, we should be erring towards the side of openness. It's just much more in line with your values and the community's expectations of how we perform and their view of their trust of us carrying out each of our responsibilities. Thank you.
Yeah, and there are tools. I don't know. It looks, many members, we have many different members with many different approaches. Some of them will use that agenda item and they call the agenda item items for future discussion or items for future meetings. It gives you that space within a clear, safe, without any risk on the OML issues of having that check in on, do people have issues we want to float or what have you. All right. Any other questions for me?
So,
Thank you, Mayor. Thank you, council.
Thank you so much.
thank you, Sam. Thanks for being here.
Yeah, thank you.
You know, I want to say to my council that I'm going to try my hardest to be more patient, more civil, and more polite.
Oh,
Thank you. And apologize for any past abruptness, which happens sometimes. Thank you.
yes. Thank you.
I'd just like to say that after going over this, I think we do a really pretty good job of following these guidelines already. I know we still have some work to do, but this meeting has made me feel pretty good about our council and what we're doing.
Yeah.
I'd agree.
I share that
Thank you.
commitment to work through it. I think it's important.
So where we go from here is, this is, I felt was like a really good touch base for all of us. Sam's great at reminding me when I've put my Ohio law back in and when to pull it out. Jim has to do that to me occasionally as well, after it being so ingrained in me, to make sure that we have things on track here. I'll be following up with you, asking you to do a bit about postmortem individually as homework exercises of what's been your best and worst public meetings. As we start to dive into our first discussion next month on your rules and regulations, and part of that's going to be reviewing some of your guiding documents, like your oath of office you took, the city charter, the mission statement, the code of ethics, the core values, really to say, what do you want out of this process? So just to let you know where we're headed. Thank you.
That's awesome. Thank you.
Thank you again for coming on.
Yeah, thanks, Sam. Thank you to all you guys for joining us. Thank you to GrassRoots, of course. Tomorrow we are back with a regularly scheduled meeting that starts at 5 p.m. We have a site for council. We have a site visit tomorrow at 4. There is a ride arranged for us, so you can be on the west side parking lot here at City Hall at about 10 till 4. That'd be great.
Just to clarify, the address is the site visit will occur at 949 Smuggler for the benefit of the public, i.e. Carolyn, listening?
Hello, Carolyn.
And it is posted for us.
It is.
I hear that.
And that is quasi-judicial, so we can't talk about substantive
Don't talk
matters.
about Bruno. No.
But then, of course, our regular meeting at 5 o'clock, citizen comment starts our meeting. So if any citizens wish to address council, please join us tomorrow at 5. Thank you, GrassRoots.
Thank you, Cory.
Thank you.